Hello, and welcome to our PENTalk, Deciphering and Applying the Most Critical Terms of Your 401k Plan Document. I'm pleased to introduce our expert presenter today, Tom Leader. Tom is an Assistant Vice President of Consulting Services for Pentegra. Tom works with clients across the country to develop effective plan design and benefit compensation strategies, manage plan level modifications, and build employee awareness and appreciation for retirement programs. Tom has been with Pentegra since 2006 and brings a wealth of knowledge and expertise and experience to our broadcast today. Tom, welcome. Thanks for speaking today, and I'll hand it off to you to get started.
Thanks, Beth, and thank you all for taking time out of your day to join us for this session of PENTalk, Deciphering and Applying the Most Critical Terms of Your 401k Plan Document. The regulations call for a written plan document that spells out the governance of how the plan is to operate and be run. So without a written plan document, essentially there is no plan. And I think for most cases, most employers, the plan document sits in a file in a filing cabinet for long periods of time, and it's by far not front and center. But if you think about the fact that, without a written plan document, there is no plan document, there is no plan. The point of this, one of the messages of this presentation is to highlight the fact that that plan document should be more front and center than it typically is. Understandably, we look at these plans as investment accounts with statements and balances, websites, a flow of information and transactions to and from the plan. But behind the scenes, those written terms are really what governs how they're run. So important facts about plan documents. One of the main pillars of ERISA qualification for these plans is operational compliance, essentially meaning following the terms of the document. Failure to comply with those written terms involves IRS and Department of Labor penalties and costs to correct those errors and omissions and oversights. Often we hear employers and clients say, well, it wasn't our intent to do, what's written in the document, X, Y, or Z, or, our benefits policy states this, that, or the other thing, which is in conflict with what's written in the terms of the 401k or profit sharing document. But those reasons, don't protect against failure to follow the written terms of the document. So, if you think about it, if all that mattered was what the intent was meant to be, the plan document would essentially be rendered useless and meaningless. If all that mattered is what was claimed to be the intent. So keep that in mind. The other thing to think about is that the overall operational compliance of the plan is important, and no provision is more relevant than any other. Generally, there are no de minimis failures that should be disregarded. So there are certain provisions that we're all well aware of. What the matching formula is, how vesting works, for example, what the eligibility is. But at the end of the day, whether it's 30 pages of provisions in your plan document or 100, they're all important. So the bottom line is that you need to follow the written terms of the plan. If those written terms don't agree with what your intent is, you can always amend the terms. But the internal procedures and policies of the employer need to be updated to ensure that you comply with the written terms of the plan. So, as I said, there's often 30 or more pages of provisions. What we're going to focus on today is 9 of them that are kind of more front and center on a day-to-day, week-to-week, month-to-month, or year-to-year basis. And so if you get a handle on these, you should be way ahead of the curve in terms of avoiding the most common pitfalls and blind spots that impede these programs from an administration standpoint. So the first critical provision is who's excluded. Does your plan specifically exclude any categories of employees by type of employee? If so, who? If they're not specifically excluded, then all categories of employees, or those categories of employees, I should say, would be eligible. And it's important to keep in mind, generally, the perspective that the IRS and how these plans are written come at these plans is generally the plans specify and define who's excluded, not who's included. So often we hear clients and sponsors say, well, we only include full-time employees. Well, really, the way the documents work is everyone's included, and those that are excluded are by name, not vice versa. You don't say who's included, and because they're not named, it's assumed to be they're excluded. So that's kind of the perspective that you should come at these plans as well. You kind of default to everybody, and then name who's excluded, not the other way around. But the risks with this provision, getting it wrong, if you exclude categories of employees that are not excluded in the terms of the plan, such as interns, part-time employees, hourly paid, independent contractors, seasonal, temporary employees, etc., then you're wrongfully excluding people from participating in these retirement benefits. These are common exclusions that we see out there. Part-time is actually not an allowable exclusion, but sometimes it comes up. Or if you allow employees who are otherwise excluded to be in the plan to participate, then you're also in violation of the written terms of the plan. And again, often we hear a client say, "Well, what's the harm in allowing additional people to participate?" Again, it goes back to whether or not there should be any discretion about which provisions in the plan get followed and which don't. There's also a key component here. You always want to be very consistent with how you apply these provisions. And while at face value it might be perceived as a benefit to allow additional people in the plan, there's someone out there that could argue in some way that it's discriminatory. So keep that in mind. Another critical provision is eligibility. What's the initial waiting period to join the plan? Does that waiting period also require a certain minimum number of hours of service? So, for example, your plan might require 3 months of service before someone's eligible. That 3 months might also include 250 hours of service during those 3 months. Some plans include an hours requirement, some don't. So it's important to understand both. Is there an age requirement to join the plan? Often we see age 21 as the age you need to be before you can join the plan. Sometimes it's lower than that. And are there different requirements for employee elective deferrals versus employer contributions? That's also known as dual eligibility. So often an employer will allow an employee to defer their own money into the plan after 1 month of service, say, but they need to work 12 months before they're eligible to start receiving employer contributions. So it's important to understand the eligibility, of course. If you don't, you make a mistake, you're essentially excluding employees who have met the age and service requirements from participating, right? Excluding them from those benefits, or you actually allow employees who haven't met the age or service requirement to participate or join the plans too soon. Entry date. So once the age and service requirements have been satisfied, when do contributions actually begin? That's what the entry date governs. So essentially, okay, you've met our age and service requirement. Now you're allowed to join the plan on such and such date. And the entry date, some of the common options is the same date that the age and waiting period was satisfied. More commonly, you see the first of a pay period, or even more common, the first of a month or the first of a quarter that coincides with or immediately follows the date that age and waiting period were satisfied. And most times, if you're going to limit the number of entry dates to quarterly, let's say, or monthly, that's purely from an administrative convenience. So you only look at it 12 times a year or 4 times a year, as opposed to 26 or 52 times a year in terms of who's eligible and when you have to add people to the plan. If a plan has dual eligibility, it's important to note the entry date typically also applies for employer contributions. So if you have dual eligibility, you also usually would have 2 entry dates, one for the employee deferrals, and that same entry date criteria would apply for the employer contributions. This is particularly important, for example, if a client makes a year-end profit-sharing contribution. Let's say you have a 1-year waiting period for people to join the plan, and one of your employees satisfies that 1-year waiting period on November 1st, but you have a quarterly entry date. So the next possible entry date after November 1st date that they satisfied the waiting period would be January 1st. So because the entry date is January 1st, they would not be eligible for that profit sharing contribution in that year that they met the 1-year waiting period in November. They'd have to wait till the end of the next plan year because of that entry date. So you can't look past the entry date for employer contributions if your plan does include dual eligibility. But the risks with that is you're either not allowing someone to join the plan when they're eligible or too soon. You're either accelerating or postponing when participation begins and therefore when benefits begin. So that's the risk with that. Contribution types, another important provision. What types of employee and employer contributions are allowed in the plan? Employee payroll deferrals include pre-tax, the traditional way that people contribute to these plans, the Roth 401k, which is becoming more and more popular, and kind of an older feature that you don't see that often these days is the old after-tax source of contributions. Employee rollovers is another source of money from a previous employer 401k or a traditional IRA, and the employer contributions would include a match, profit sharing, which is also known as a non-elective contribution, and perhaps a safe harbor match or a safe harbor non-elective contribution. So these are some of the common contribution types. There are others, but these are the most common. So you want to make sure that you understand what type of contributions are offered. First, from the employee deferral piece, you want to make sure those are coded correctly for tax treatment. Employee Roth deferrals, if they were coded as pre-tax or vice versa in the payroll system, obviously that impacts people's taxes. And allowing for a type of contribution not permitted by the document or disallowing one that is permitted, such as a Roth 401k or a match or profit sharing, also would create problems. So, often we hear clients, again, very understandably, they might refer to any type of an employer contribution as a match, when in reality they're actually making a profit sharing, or vice versa. They might call their match a profit sharing. But they're two very different things in terms of the document and how the plan is structured. So a match only goes to people who defer their own money into the plan. If you don't defer your own money, you don't get any piece of the match. And how much match you get depends on how much money, your own money, you put in the plan. Profit sharing, on the other hand, goes to anyone who's eligible for that contribution. You don't have to defer your own money to get it, and the amount you get is not contingent on how much you defer. So important to differentiate and understand the terminology there as well, worth mentioning. Compensation, that's one of the most commonly misunderstood provisions out there, also one of the more complicated parts of plan administration, but one of the most important ones as well. So how does the plan define compensation for purposes of calculating employee deferrals and employer contributions? And if you think about it, compensation, is just as important as, the deferral amounts, elections that participants make, as well as the employer contribution formula, because those usually almost universally are based on percentages of compensation. So it's one thing to know what the percentage should be, but if you're using the wrong form of definition or compensation rather, you're going to get the wrong contribution amount. No different than if you hadn't applied an employee deferral amount correctly, or you used the wrong formula to calculate the amount of the contribution. So very important to get compensation correct because it directly impacts the level of benefits that people get. Important to understand whether or not the same definition of compensation applies to both employee deferrals and employer contributions. It's a little bit uncommon, but not completely unseen out there, where an employer might say, we're going to allow an employee to defer income from all sources of compensation, not just only base salary, but bonuses, commissions, anything and everything. Whereas for employer profit sharing contributions, let's say they might say, well, bonuses is already an additional benefit. We're not going to give you profit sharing on top of your, including your bonus. So they might base the profit sharing purely on base salary. So it just depends. And if you do have different definitions of compensation for employer contributions than you do for deferrals, it's also important to note, well, does that definition for employer contributions apply to all types of employer contributions? Again, it's quite possible that the document specifies that certain forms of compensation are only excluded for profit sharing, but not for match. So keep that in mind. Very commonly, plans might have the exclusion where the compensation earned prior to an employee becoming eligible to join the plan is excluded. So again, let's pretend that you have a 6-month waiting period to be eligible for the plan. You hire an employee on January 1st. They become eligible July 1st. The end of the year, you go to make your year-end profit sharing or matching contribution. If your plan stipulates that compensation is excluded for the period of time that someone wasn't eligible, for that particular person who wasn't eligible till July 1, you'd have to factor in the first 6 months of the year, that compensation is excluded. And you base your employer contribution just on the second 6 months of the year that they were eligible. Most often, employers say, once you're eligible, you're in, and we're going to calculate your contribution on the full year of compensation, even for the period of time you weren't eligible. But some employers understandably want to carve that piece out. So you got to pay attention to that if that's the case in your plan. And worth mentioning, post-severance compensation. Is it included or excluded? Most plans give you the option whether you want to include it or exclude it. And by post-severance compensation, I mean compensation that would be ordinarily paid out to the participant had they kept working, as long as it's paid within 2.5 months of the date of severance. So understand that. It's a question that comes up from time to time. True severance compensation is never included. And by true severance, I mean compensation that's paid as that's dependent or contingent on someone retiring or terminating service. But common options of compensation would include W-2 compensation. So any form of compensation that shows up on a W-2 form would be included when calculating employee deferrals or employer contributions. And that would include non-cash forms of compensation as well, including things like the taxable benefit, the taxes on the employer-paid portion of a group term life premium benefit, or gift cards, for example, other things. Another common option would be W-2, excluding certain forms of compensation like reimbursements, benefits, or expense allowances. And again, much like eligibility, the perspective here should be, you start with an all-encompassing definition of compensation typically, and then you specify by name what's excluded. Again, often employers come at this with the wrong or the opposite perspective, I should say. They'll say, well, we only include base salary or base salary and commissions kind of thing. Really, more commonly, the way it's stated in the document is everything's included, and these 3 things or 4 things are excluded, not the other way around. These 3 things are included, and everything else, because it's not named, is excluded. So, again, keep that in mind, the perspective, how you come at this. Usually you start with a very broad definition and back things out that are excluded. But not uncommon to see it named as what's included. And when you see it that way, often it's just base salary or base salary plus bonus and or commissions and overtime. So that's compensation. But again, as I said, the risks there, if you're using the wrong definition of compensation, you're either shortchanging participant deferrals and employer contributions, or you're over contributing to people's accounts. And again, back to the perspective, well, what's the harm in over contributing? Well, it could be deemed to be discriminatory very easily. For example, if you're including bonuses when you shouldn't be, and the majority of the bonuses get paid to highly compensated employees, that could very quickly look like it was discriminatory, even if that wasn't the intent. So keep that in mind. Deferral limits, critical provision. Does your plan limit the amount or form of employee deferral elections? Most plans don't anymore. Most common options, you're allowed to defer up to the maximum amount allowed by law. But once in a while, you do see a plan that might cap deferral percentages at 50% of pay, let's say, or 75%. Usually not an issue, but every once in a while, it can cause an issue or a mistake or an oversight. But the form of deferral election also is worth noting. Most plans only allow a percentage election, understandably, and that's usually the best because as pay goes up, deferral amounts automatically increase each year as well. But some plans also allow flat dollar elections. Usually it's the highest paid or the lowest paid people that are interested in making a flat dollar election, if at all. But the risks, obviously, you don't want to cap participant deferrals unnecessarily below IRS limits. Um, Often we see, sometimes we see people that are working to save, right? You have a dual income household. One of the spouses is maxing out their savings to make up for lost time, perhaps, and they're wanting to defer a large percentage of their pay. You wouldn't want to cap those people unnecessarily. Also, you don't want to allow contributions that exceed the plan imposed limits as well. So those are the risks with misunderstanding that provision. Deferral changes, more of a housekeeping issue. How frequently can participants stop their deferrals or increase, restart, or decrease them? Often that's not one and the same. Frequently, documents will allow participants to stop their deferrals anytime they want, but when they can restart them or how frequently they can restart them or increase or decrease them might be limited. But so you want to understand that. Also, are special elections allowed for special pay, such as bonus payrolls? Um, Not all documents allow special deferral elections that apply just for bonuses. Many do. Usually, the norm is that if they're allowed two choices there, and absent an affirmative election, are you going to use the regular pay that is applied to base salary, or are you not going to withhold anything at all from the bonus? Often employers will just say no special election allowed, and whatever your regular deferral election is at the time is also going to apply to the bonus, assuming that bonus is included in your definition of compensation. But pay attention to the nuances of bonus payrolls and make sure you're affording your participants all the options they have to manage them. But again, the risks there, you're not properly allowing people to manage their account. That might result in them having an over or underfunded contribution, and including the employer match if that's impacted by deferral amounts, right? So you can see an ancillary ripple effect, one provision kind of mistake leaking into another correction. So the employer match, what's the stated formula? Usually that's very well understood. More commonly, what might get lost or slip through the cracks is whether that contribution technically should be contributed and calculated each pay period or all at once at the end of the year. If at the end of the year, often there are allocation requirements that need to be met each year in order for the participant to be able to receive that match for the year. Typically, it's either a requirement that you're employed on the last day of the year. For most plans, that's December 31st, and/or you need 1,000 hours of service during the year to get that year's contribution. So that's something that sometimes is a little cloudy for people. You have the initial waiting period to become eligible for the plan in the first place, and then if you make a year-end matching contribution, you might also be required to work a certain number of hours each year in order to get that year's employer contribution or be employed on the last day of the year. So if you do have those allocation requirements, you want to make sure you follow them. Also, you want to make sure you know in the event that someone isn't employed on the last day of the year, or they didn't have 1,000 hours during the year due to dying during the year or becoming disabled or retiring, do you still want to give those participants that year contribution? You can make an exception for those folks and waive those allocation requirements in those three situations. So you can't lose sight of them. And then also, if you do make a pay period match, often the plan document calls for or gives you the discretion to make a year-end true-up contribution. So essentially, that is, well, we know what we calculated each pay period, but for those participants that might have contributed more out of some paychecks and less out of others, whereas they didn't get the full match each pay period, but looking at their contributions in total for the year, they should have maximized the match. You go back and look at it and say, well, what should the match have been based on the full year? What did they actually get on a pay period by pay period basis? If you owe them a little bit, you true them up, give them a year-end contribution to kind of make them whole. So need to understand the true up if that exists, and whether there's a discretion to do it on a year-to-year basis, or you have to do it or not allowed to do it for that matter. But that's the risks with misunderstanding these. Again, you either end up over or under contributing to participant accounts, and that's something you don't want to do. Profit sharing, again, also known as a non-elective contribution. Same as the match. Obviously, you understand what the formula is. Often it's discretionary. It's not stated, and it's just determined on a year-to-year basis. But again, understanding whether it's calculated each pay period or at year end, what those allocation requirements are, and if they're waived in any situations. So that's the profit sharing. Again, the risk is you either over contribute or under contribute to participant accounts. It's worth noting you want to understand that and be sure you're differentiating specific name sources and provisions. So as I said earlier, the employer match is different than an employer profit sharing. A safe harbor non-elective contribution, for example, is different than a safe harbor, a non-safe harbor non-elective contribution, I should say. So, to participants and employers, again, very understandably, these may appear to be the same, and those terms sometimes get used interchangeably. However, the document differentiates between the two very clearly. And so, you need to do that operationally as well, and as well as in your mindset. So if certain plan provisions apply specifically to one and not the other, for example, the right to take loans or certain compensation exclusions, you really need to differentiate operationally speaking as well. And when amending provisions, that's also pretty critical. You want to pay careful attention to other provisions that apply specifically to provisions being removed or added. So let's pretend you're making a matching contribution for, years and years and years, dollar for dollar on the first 5%. And philosophically, you change your benefit approach. And in year 10, you say, you know what, we're going to go to a 5% profit sharing contribution. And previously, you had a compensation exclusion. Maybe you were excluding, bonuses and commissions from the match. You amend the plan, you add a profit sharing contribution, things look great. You go to make your contribution at the end of the year. You put your 5% in based on base salary because that's what you've always done and that's what was stipulated for the match. However, when you amended for profit sharing, you didn't amend the compensation definition to also stipulate that bonus and commission should be excluded from profit sharing. In that situation, you would have to provide a profit sharing on all those forms of compensation, because when you amended one provision, there was an ancillary provision that was connected to that was being removed, and you didn't update the other provision. So pay careful attention to that so that you kind of avoid those pitfalls with document amendments. But again, the risks, either over or under contributing to participant accounts and not necessarily providing all the benefits, rights, or features properly for each of those. And although not specifically stated in plan documents, by no means can the plan exceed IRS limits. So keep that in mind. you can't exceed these limits that are laid out here, the 2018 limits. So, considering provisions, absent understanding these provisions, the IRS limits, can also get you into some hot water. Uh, so to summarize rather, and basic recommendations. Really, it's key that to ensure that any employee who's charged with any type of plan administration is familiar with all the written terms of the plan document, trained properly so they can understand in layman's terms what they need to be doing on a day-to-day basis, that all people get notified of provision changes. So when the committee decides to amend the plan and follows through on that, you have to make sure that that notice is distributed to all the payroll, HR, and management that handles the plan, so everyone's on the same page. And then you want to periodically review those plan provisions, whether it's once a year, twice a year, quarterly. Pull that document out, compare it to how you're operating on a day-to-day basis, and make sure everyone's synced up. You want to focus particular attention on these 9 critical provisions. As I said, all the provisions are important to understand. They all matter, but these 9 critical provisions are the ones that most commonly result in infractions and corrections and penalties. So if you understand these 9, you should be doing yourself a favor in terms of getting ahead of the curve on plan failures. And last but not least, when in doubt about a provision, double and triple check with your provider or legal counsel if there's any sliver of doubt whatsoever. I know as a provider and partner with many clients around the country, I always tell my clients that I work with this fact. We don't want to go through a correction as much as you don't want to go through a correction. So even if it's on every year, you need to confirm the same thing at year end before you make a profit sharing contribution. Much better for everyone if you do that than to make an assumption that's wrong, that might go unnoticed for a few years and create a larger correction down the road.
Good tip there, Tom, at the end. I think we can all benefit from that. So thanks, Tom, for presenting all this great information today. It was very informative. We hope that all of you enjoyed the presentation and will find this information helpful to you in administering your plan going forward. Thanks for joining us today, and we'll see you on our next PENTalk.